Thank you very much for the recognition, Madam President. And I also rise today to oppose the nomination of Scott Pruitt to be Administrator of the Environmental Protection Agency. I believe the President should be able to assemble his or her own team, and I understand that elections have consequences, and that a President should be able to put forth his or her policy agenda. I voted on this floor many times in support of nominees with whom I have policy differences, but they have been qualified, experienced in their field, who believe in the fundamental mission of the agency they are tasked to lead. That is not the case with Attorney General Pruitt. Mr. Pruitt has extreme environmental policy views, and he has zero experience running an environmental protection agency. In fact, he does not believe in the fundamental mission of the EPA. Attorney General Pruitt made his name opposing EPA rules that protect human health and the environment, fighting against clean air and clean water, disregarding the science behind the EPA's protections for human health and the environment, on behalf of for-profit special interests, not the public interest. He has brought 19 suits against the EPA. 8 are currently pending in the courts, and if confirmed, he won't recuse himself from all the pending cases. As a lawyer, and especially as your state's top lawyer, you shouldn't change sides in litigation. It's just not right. There may be an ethics violation here. I've never heard of a lawyer representing both sides of a case. Let's look at just a few examples from his litigation record, starting with his opposition to clean air. Mr. Pruitt is leading litigation against the EPA's ozone or smog rule. In 2015, the EPA revised its ambient air standard for ground-level ozone. The EPA was long overdue in revising its ozone standards to protect public health. It even had to be sued by states and environmental organizations to make sure the standards adequately protected human health. High concentrations of ozone are bad for public health. Children, older adults, and people with lung diseases, such as asthma, are especially vulnerable. The EPA set a standard of 70 parts per billion. This standard is based on the best science, which included thousands of studies analyzing the effect of ozone on public health. In addition, the EPA built in flexibility for states that would have trouble meeting the standard. But the Oklahoma Attorney General currently leads a 4-state charge to do away with the rule. Mr. Pruitt thinks it's okay for power plants to emit unhealthy levels of mercury and other toxins into the air. In 2011, the EPA passed the mercury and air toxics standards. The rule limits emissions from power plants of mercury, arsenic, and other metals. Like the ozone standard, this rule was long overdue, and the EPA was forced by the courts to develop the standards. The science is well established that these toxins are a serious public health threat. Fortunately, there are proven and available technologies to limit the emissions. Scott Pruitt fought the mercury and air toxic standards. He's still litigating in court against the standards, even though the vast majority of power plants in the nation are currently in compliance with the standards. Just to show you how serious this is, in my home state of New Mexico, pregnant women and children can only eat a very small amount of fish from the streams in New Mexico. Our streams are polluted with mercury. The levels are so high, vulnerable populations are advised to severely limit their consumption. Scott Pruitt wants to continue this pollution of our streams. Mr. Pruitt testified in his hearing before EPW. He saw a role for the EPA to address pollution that crosses state boundaries, but his litigation history does not support that testimony. As Oklahoma Attorney General, he fought the EPA's cross-state air pollution rule, a rule designed to recuse power plant emissions to reduce power plant emissions that cross state lines and cause smog and soot pollution and health problems in downwind states. Especially the cross-state air pollution rule reduces sulfur dioxide, or SO2, and oxides of nitrogen, or NOx, emissions. NOx emissions contribute to fine particle and soot pollution and to ground-level ozone formation, otherwise known as smog. Even though this pollution affects the air and health of downwind states, Mr. Pruitt sided with the power plants. Air pollution is not the only problem that crosses state lines. River and stream pollution does not stop at state boundaries either. The EPA and the U.S. Army passed the Clean Water Rule in 2015. The rule clarified a dizzying set of Supreme Court cases defining protected waters. The EPA and the Army used the best science, reviewing more than 1,200 peer-reviewed published scientific studies to define protected waters. New Mexico is an arid state. We have very little surface water. We need to protect all of our surface water for domestic, agricultural, and industrial and recreational uses. And by the way, the EPA and the Army's definition of surface waters is no broader than my own state's definition of surface waters. In New Mexico's definition is appropriate and reasonable to protect our precious surface water. The Attorney General of Oklahoma is fighting the Clean Water Rule too, even though it protects against cross-state pollution. One more example, Madam President, the Clean Power Plan. The Clean Power Plan is our country's best effort to address climate change. We know that climate change is happening. We know that climate change is primarily caused by humans. We know that power plants are a major contributor. We know that we need to take action and that we need to take action fast to protect our planet. The Clean Power Plan significantly reduces carbon dioxide emissions from existing, modified, and future power plants. The Clean Power Plan was developed based on the best science. It was developed based on a tremendous amount of input from states, industry, environmentalists, and others. It provides states with a lot of flexibility how to comply. Mr. Pruitt, true to form, is litigating against the Clean Power Plan. Mr. Pruitt apparently does not understand the science of climate change. In the National Review in 2016, he wrote, and I quote, "Scientists continue to disagree about the degree and extent of global warming and its connection to the actions of mankind," end quote. During his confirmation hearing, he similarly stated, quote, "Science tells us that the climate is changing and human activity in some manner impacts that change. The human ability to measure with precision the extent of that impact is subject to continuing debate and dialogue, as well as they should be." That is not what science tells us. That is maybe what fossil fuel special interests tell him, but that is not what science tells us. His views are not consistent with the scientific consensus on climate change. The 2013 report from the Intergovernmental Panel on Climate Change found it extremely likely that more than half of the global warming that occurred between 1951 and 2010 was a consequence of human emissions of carbon dioxide and other greenhouse gases. So many of the decisions made and the regulations passed by the EPA rely heavily upon good science. It is absolutely critical that the EPA administrator understand and use the best science. I'm not convinced that Mr. Pruitt understands and will use the best science if he is confirmed to lead the EPA. When developing regulations, the EPA must first follow the law's requirements to protect human health and the environment. Then, within the law's requirements, the EPA should take account of input and information from all sources, from industry, environmentalists, states, and public agencies. I am not convinced that Mr. Pruitt will follow the law's requirements to protect public health and the environment, and I'm not convinced that he will take account the input of all stakeholders. Throughout his career as Attorney General, Mr. Pruitt is aligned solely with industry and against public health and the environment. He has no record of aligning with the public or of securing our environment for the future. As Attorney General, he engaged in a scorched earth policy against environmental regulations. He dismantled his Environmental Protection Unit. He became very close politically to the energy industry. He adopted letters written by energy industry lobbyists, almost verbatim, and then submitted them on behalf of the state of Oklahoma in federal legal proceedings. As the chair of the Republican Attorneys General Association, he became even more closely aligned to the fossil fuel-related companies. Mr. Pruitt's record is one-sided and extreme, and does not give me confidence as EPA administrator he would have any commitment to protecting public health now or protecting the environment for future generations. And finally, Madam President, I'm concerned that Mr. Pruitt has not shown and does not have the proper respect for tribal sovereignty. Oklahoma is home to 39 tribes. Mr. Pruitt's litigation history as Attorney General has consistently been anti-tribe. As Vice Chair of the Senate Indian Committee on Indian Affairs, I pay special attention to nominees' records on tribal issues, especially nominees for agencies who will deal with tribes on a government-to-government basis, like the EPA. As Oklahoma's top attorney, Mr. Pruitt routinely sought out ways to fight tribal sovereignty, even all the way to the highest court in the land. In a case called Indollar General Corp. Versus Mississippi Band of Choctaw Indians, Mr. Pruitt filed an amicus brief in support of a corporation that refused to submit to tribal jurisdiction. Mr. Pruitt's side lost. This case is a prime example of Mr. Pruitt's misguided views of tribes and their inherent sovereignty. Indian country needs an EPA administrator who respects tribal sovereignty. I'm not convinced that Mr. Pruitt does. And just recently, we had in town the National Congress of American Indians. They submitted a letter for the record on January 18th. I would ask consent to put that letter from the National Congress of American Indians in the record.
Without objection.
Thank you, Madam President. And I would like to just read a couple of paragraphs from that. On behalf of the National Congress of American Indians, the oldest, largest, and most representative American Indian and Alaskan Native organization serving the broad interests of tribal governments and communities, and this is from the President, I'm writing to express our deep concern with the nomination of Oklahoma Attorney General Scott Pruitt to be the administrator of the Environmental Protection Agency based on his history of fighting environmental regulations and the new administration's statements denying the existence of climate change. The continuing impacts of climate change are a major concern of tribal nations, and before this committee votes to move forward with Attorney General Pruitt's nomination to lead the EPA, it must thoroughly consider the potential impacts of his nomination and what impact that will have on climate change, the protection of natural resources, and the protection of tribal trust and treaty rights. American Indians and Alaska Natives are disproportionately impacted by climate change due to our geographic areas and direct connection and reliance on the surrounding environment. It is threatening to destroy our lands, our waters, our natural resources, which will impact our tradition and customary ways of life that have been sustained for thousands of years. We are at a critical moment in combating the increasing climate change effects from human-made sources. Indian country, the United States, and the world cannot afford to take a back seat in fighting climate change. Now, in conclusion, Madam President, my concerns about Mr. Pruitt's record on environmental policy aren't just because we disagree on policy. Mr. Pruitt has made his reputation litigating fiercely against the EPA's most important regulations to protect public health and the environment, clean air, clean water, toxics on the land, you name it. Regulations that comply with federal environmental laws that are based on good science. They have taken years to prepare and that have taken fair account of all stakeholders' input. I cannot support a nominee to lead this agency whose record is so hostile to the environment. For all these reasons, Madam President, I must vote no on Mr. Pruitt's nomination to be EPA Administrator. And just finally, we have today the court ordering Mr. Pruitt to release a large number of records that are relevant to this particular nomination. He refused to release them. The administration in vetting him did a very poor job. As you know, they don't vet anybody. They throw it up here, and we have to do the vetting. And that's our job, to do the vetting. Well, this is a critical part of the record, a vast number of emails that should be looked at. And so many of us believe we should have the time to look at these emails, deliberate about them, maybe even ask some written questions to Mr. Pruitt on them. But this nomination is being rammed through. In a couple of hours, we're going to have a vote. Luckily, Senator Merkley is going to urge that we vote to delay this so that we can have a chance to look at those emails, and so that all of us, all 100 senators, have the opportunity of having a full, complete record on Mr. Pruitt. And with that, I would yield the floor, Madam President.